95.3 WDXE.
And good morning, Lonnie Box filling in for Jeff Hood this morning. He had an appointment he had to get to, and I gave him a hard time about it, but I'm here with Stan Pierchoski and Bulletproof Estate Planning.
Good morning, LB. Good morning. I guess we don't need our headphones, right?
I mean, if you want them, you can use them.
I mean, I can hear myself. And that's
I hadn't got none on because I don't have mine back here.
Well, as long as it's okay. I mean, as long as it can still broadcast okay. I don't typically need it, but
Yeah.
anyway. No, I appreciate it. You know, we do this every Friday morning, Bulletproof Estate Planning, from 8 to 9 here on WDXE. And we have this as a call-in show. And so I like to tell people, sometimes I forget to give the number out, but if I want to make sure that if you want to call in with something, question about estate planning or, you know, anything along those lines, you can do so. Just call 931-766-9393. That's 931-766-9393.
And that spells out to WDXE.
It does.
Yes.
Why that's not surprised me. So anyway, you know, so what's going on? We just had a seminar not too long ago. We got another one coming up. It's a little ways off. We do them every other month now, and the next one is going to be after all the holidays. It's in the later half of January. So it's January the 24th. It's a Saturday. We're going to be doing that one at the Star Theater over in Pulaski. So
Okay.
It's not too early to sign up for that, but it is a little ways out. I don't like to do them around the holidays because, you know, I want to celebrate them as much as everybody else, and you know, it's just everybody's got a lot of things going on in holidays. It seems
Now, your last one was in Franklin, right?
it was.
How did it go?
It went pretty good. They have a nice venue. It was the first time we've been up there. It was the Williamson County Public Library, and they have a real big room. Could have fit, gosh, I don't know, probably 150 people in there. But it was a good seminar. We had several people engage and had a lot of questions and stuff like that. So, but like I said, this next one will be back in Pulaski, and then probably shortly after that we'll be back over here. But the girls plan it for the year. I don't look too far ahead, but my horizon is a little closer because I'm more in the feeding the alligator that's closest mode, you know. But they do plan it at least 6 months ahead of time. So, because they got to make sure they get the venues and stuff like that. So, because we got that venue, I think we had to secure it back in October or something because just because the way they do it. And so, anyway, I want to mention something about you know, we deal with the Star Theater over in Pulaski. I know you folks have an arts, a community arts system over here as well. And I wanted to just give a shout out and a thank you to the folks listening because I know, you know, we cooperate with the Arts Commission over here as well. And I know you guys had a Christmas show, and it was like it was completely sold out. So
Yes.
And we have Nutcracker starting tonight over at the Star Theater, which is this weekend and next weekend, Friday, Saturday, and a matinee both weekends, and it's completely sold out. So I mean, I appreciate the folks. With all the crazy things going on in the world, you know, it's nice to see people still seeking out the arts and attending and supporting and doing all that. It's really, you know, it's just good to see.
Yes.
You know, I have always thought it was good entertainment. I mean, you know, to go out to a show, a 2-hour show, and get that kind of, you know, entertainment. I mean, you know, for whatever the cost of the ticket is. I mean, it's just a good deal. It's a good bargain. I mean, it's better than watching a movie. I always thought so.
No, true.
Actually,
Get out of the house a little bit.
One of the first dates, if not the first one, the first one wasn't really a date, but the first real date I took my wife on when I first met her was, I wanted to impress her, right? When during the first couple of dates, that's what you wanted to do. And I lived down in Alabama, in Harvest, Alabama. It was when I was working in nuclear power, and I actually was working at the Browns Ferry Station down there. And she lived in Decatur. And she worked out there too. But anyway, they were at the Huntsville, down at the Civic Center, I guess, or the theater. I forget what it's called in Huntsville.
Von Braun.
The Von Braun, yeah. They have the Civic Center, and I guess the theater's in there too. They had a play. It was a Antigone. It's like a Greek mythology kind of a play. It was a live performance, so I thought, you know, that'd be pretty cool. So I bought tickets for that. We took her to a play. And she was very impressed. So.
Oh, good. And the rest is history.
Well, and the rest is history. You know, I don't know if that impressed her more, or that was back in the days when I was a pilot. I guess I still am. I just don't stay current. You know what I mean?
Okay.
But I had a plane, and I was still. I was already a pilot, but I was learning an instrument rating, which is another rating you get after. And One Saturday morning, my instructor and I got together, and I invited her to come along if she wanted to ride along. And so that was actually the first. It wasn't really a date because it was very early on a Saturday morning. She rode along in the back seat of a plane. We had a Cessna high wing, and we were buzzing around a little bit. She was pretty impressed by that. Except, this is a funny story, and since I started, I guess I better finish it. And that is, she got in the plane, and we're driving, and my instructor was a friend that we both did a lot of scuba diving. And so we were just flying around doing some maneuvers, and we would see a couple quarries. And around here, if you want to scuba dive, you got to scuba dive in a quarry because there's no ocean. So we find a couple of those, and we would put the plane in a steep turn, and look around, see what roads led up to it, and maybe go to that someday. And then we went back to the airport and did what we call touch and goes, where you set up for it's a way to practice landing. You set everything up, you come in on final approach, you land the airplane, you power everything down, and before then at some point you just power everything back up again and keep going and take off again. And you can do that several times to practice landings. Well, what I didn't realize was it turned around and looked, and she was in the back seat, looked like she was about ready to hurl. And it turns out that she's very prone to motion sickness.
Ooh.
But she was hanging in there. But I look back at it and say, no, that was love. She put up with all that just because I invited her along. But she was okay once she got back on her feet on the ground.
Yeah. Man.
But anyway.
That's a rough start right there, Stan.
Which has nothing to do with estate planning, except for the fact that we ended up getting married, had a family, and we did some estate planning ourselves. So maybe I can tie it together that way.
There you go.
But I wanted to talk about something that I didn't bring any paperwork with me, but I can do it from memory. And I talked about it yesterday on the Plasky radio that used to be one of yours, but now you guys have severed that one off. But it was about a court case I was following out of Murfreesboro. I wasn't following, I was kind of brought into it by an attorney that I know over there that asked me to help out. And it's kind of a sad story because when we started, we pretty much knew how it was going to end up, and now it's kind of ending up just that way. But I just want to point out, because I think it's a good example of things to be careful of, or what to watch out for when you think about doing some kind of planning, or if you don't think about doing planning. And it had to do with a husband and wife, but it was what we call blended family. Okay, it was a second marriage for both the husband and wife. Each had children of their own. I think they each had 3, something like that. But to give you a little history on it, the wife and the new wife had 3 children, and they had a specific piece of real estate. It was like a cottage or a lake house. I think it was like a lake house. And it was something that's been in the family for many years. It was very sentimental to them, and they went there, I don't know, every spring for a couple, like people would do. And it was a nice little place, according to them. And it was very sentimental. So she had always wanted that property to go to her children because of that. The husband had passed away, I think. The husband was remarried from divorce. But anyway, that was the goal. And of course, this is all the back history. But what had happened was her and her new husband had written wills, reciprocal wills, and it pretty much said, I leave everything to my spouse, but if my spouse predeceases me, then it goes to my children. And she put specific language in there about the lake house going to her children. But they didn't have any kind of prenuptial, which is sometimes a good idea on blended family, because when you have a blended family, each person's coming into the union with heirs of their own, and the heirs are not common heirs. And usually, if there's any length of time in the first marriage, people want those assets kind of go with those children. Plus, there's the thought process: if you get remarried, if I'm the first death, do I want my children to have to wait till my new husband passes away to get their inheritance, or could they get it at my death? Okay, those are some things we think about when we talk about when we have a blended family, because it's not as straightforward as somebody that's been married. It's the only marriage. So we think about that stuff. But in this case, what had happened was she was the first death. And there was some talk and there were some promises made that house was going to go to her 3 children. And the promise was acknowledged. I mean, apparently everybody was on board with that promise. And it made sense, and but it was never memorialized, okay? And the big mistake made was when they did a will. In my opinion, the first mistake is to do the will, because they're so limiting. But they said in there, what we call reciprocal wills, they said, if I pass away, everything goes to my spouse, which is saying if I'm the first death, everything goes to my spouse. But it also says if I'm the second death, in other words, if my spouse predeceases me, Then I wanted to go to the kids. And we had this elaborate distribution scheme to the kids with this lake house, how it was going to go to them and how they were going to own it. There was like, I think there was one child that lived somewhere else and didn't really want to own the piece of property, but the whole thing was planned out for a way for him to get his inheritance and keep the house with the other two that wanted to keep it. And so it was pretty, they put a lot of thought into that. And this story makes me mad because of all that, this all was talked about. So some attorney that they had that wrote these wills, in my opinion, dropped the ball. And you couldn't say, well, I didn't know, because that was all in there. But what happened was she was the first death, which meant everything went to him. Now, what's happening now is we're all banking on this promise that we made, okay? What happened was he had written another will and just left everything that he had. He didn't name the lake house. He just said everything he had was going to go to his 3 children. He didn't leave anything to the other 3 children. And then he passed away, so he was the second death. So everything that he had, which was everything that she had, because she just relied on this promise and said, if I'm the first death, everything goes to you. And if, at his death, he said it goes to his children. So a court conflict arose, and unfortunately for the wife's children, their only cause of action relied on the enforcement of this promise that was made, that was not memorialized in the testamentary instrument, which was the will. And there was had a court hearing, and like when I first got involved, I told the attorney that invited me into the case to help him out, I said, we don't have a strong argument. It's just not, and I don't think it's going to be successful. But we pitched a pretty good argument. When we make a promise, it's basically a contract. And if you don't have a written contract, it's hard to, you can have contracts that are not written. They're just as valid as ones that are. But when you don't have a written contract, then people will say, well, the terms and conditions of the contract, if it's written, we know what the specific performance of both parties is. But if it's an oral contract, now suddenly people say, well, I don't remember really agreeing to that part of it. I just, said I'd. Anyway, so that was the part it got through a hearing, and the court ruled that, if it had to have been memorialized in the will, and so that we could understand what the testator's intent was, which is exactly what the will or a trust is, because after your death, what you wanted to have happen is memorialized and expressed in this document. And it wasn't. Or what was exactly what happened to the property. And so the end result was this family didn't end up with this lake house that they so much wanted, and the deceased mother so much wanted them to have it, but they got some bad advice or something. I'm just speculating on the bad advice. And the reason I say it was probably bad advice, because an attorney was involved when they wrote the wills, and the attorney knew that the house wanted to go there because there's so much language in it if she would have been the second death. But the wide open question was, she said, if I'm the first death, everything goes to my spouse. And that was where the error was. And anybody that has any understanding of estate planning should have spotted that right away, like I did. Saw it right away, and I thought, this is going to be a problem. But anyway, maybe, I don't think they're going to contest it much further, and I don't know that the decision would change if they went to an appellate court. Mm-hmm. Because it's a question of law, and it wasn't done the way it should have been done. Or let me put it this way, the distribution of property was done the way it was okay, the way it was set up. The fact that somebody didn't get what they were supposed to get, you can't prove the supposed to get part, because now the testator's gone and nothing to express their wishes. Their only expressed wishes were if they were the survivor of the two, and that's not what they meant. So anyway, it was a sad story, but it just kind of goes to show that it's not simple as just say, well, I'm just going to write a will. I mean, you can do that, and sometimes that might work out exactly the way you want it. Let's say, like my wife and I, we are each other's first marriage, and we've been married for 38 years. Probably not going to go anywhere that I know of, so it's going to stay that way, right? And so, if I say I leave everything to her, and then if she's not there, my kids, that might be a relatively safe thing to do. Mm-hmm. But the blended family is very common. I mean, it is nowadays versus you and I were kids years ago. I mean, when we were kids, being divorced was like a scarlet letter.
Just about.
When you were a kid, look, she's divorced. Yeah. But now it's just so rampant, and the blended family is extremely common. I bet it's every bit of 50% of people that are married are blended families. Mm-hmm. I'm not saying anything's wrong with a blended family. I'm saying it takes special thought process when you do the planning, because you have, I often tell folks, Will the new spouse and the new wife and the new husband have any conflict? Maybe, maybe not, I don't know. Will the wife's heirs and the husband's heirs have any conflict? Most assuredly so. I've never seen it not be that way. Some sort of conflict. And it makes sense because, I mean, they don't know each other from Jack. They have no relationship, you know, of any bloodline, you know, nothing like that. There's nothing tying them together other than the step position that they are. And so, anyway, it's special thought needs to go into this blended family concept because the players that are involved and how they got that way. And the sad thing about the story I told is it was so easy to have done it right. It would have been so easy to have done it right.
You know, my question is, why did the lawyer that originally drew this up, why didn't he write that in that will?
So I'm saying he wrote the will.
He wrote the will,
but he
but why
put it,
didn't he?
I don't know. I mean,
That's,
no, we never got there, and I don't know if they'll get anywhere, but I mean, I consider that malpractice. I mean, but, you know, that was not what we were doing. We were trying to contest the will itself, but I think they have a cause of action for malpractice. Now, had that language not been in there for the second death, well, and again, I guess he can claim that he didn't know, but you know, it's all about proof when you get into stuff like that. And if you may or may not have it. And I'm not involved in going there, and you know, the damage is done. I don't know what they can do about it. They may be able to entertain a cause of action for
well,
that.
I'll tell you exactly, if I had a will and I had a verbal agreement that I wanted this done and it wasn't done after I passed away, whoever didn't do what I told them to do, I'd haunt them for the rest of their life.
Yeah. But the other sad part is the lawyer would just draft a will and they just thought, okay, I guess what I want done is in there. And so they don't know, you know what I mean? In other words, he draw it up and they signed it when full well, I don't know if they full well know it didn't do what they wanted it to do.
That's where you...
They relied on him.
That's where you make sure you read something before you sign it.
Yeah. I agree. You know, I have, you know, when I do my trust plans, there's a lot there to read. And a lot of my clients, a majority of them actually read it. And I like that. Because a lot of times they'll apologize, because they'll ask questions about it. They'll say, what does this mean? What does this mean? And they'll say, sorry for so many questions. I said, don't be sorry. I mean, I'm thrilled to death that you've taken an active involvement and you're looking through it. You need to be familiar with what it is and how it works. Now, when I write trusts, they're not in any kind of veiled language. I mean, when you read a contract, certain contracts can get really overwhelming with the legalese. But I don't try to hide any meaning. It's all in plain English. You should be able to, there's some legal terms in there, but nonetheless, you should be able to ascertain what it says by reading it. And then when the people that do read it, I'm more than happy for them to do it. Some people will say, you know, when you're done drafting it, can you send me a copy to look at? And I said, certainly. No, I don't have a problem with that whatsoever. I'm not the kind of lawyer that says, you need this trust, here, sign here, and don't worry about what it says. You know,
that's what you want to watch out for.
Because when you sign it, and here's one of the things that came up in that case was when you sign it, the court has to look at it. They must presume that you read it, understood it, and approved it by signature. I mean, you can't get past that. I mean, they're not here to say, well, I didn't know what it said, I just signed it. You know how many people just sign things?
Oh, yes.
I mean, it happens all the time. I mean, look at the internet. How many times does the box come up that says, these are the terms and conditions? And this box at the bottom says, I accept them. Well, if you ever click on the little hyperlink that says terms and conditions, it takes you to the actual terms and conditions. And it's pages and pages and pages long. Who reads those? I always do. I'm one of those weird guys, I always do. And
Well, maybe I should start.
They're mostly always boilerplate, you know what I mean? But I'll tell you one thing for sure, those terms and conditions like that are always heavily in favor of the person that on the other end of it, especially on the internet.
Sure.
And if you don't accept it, then you just do without it. It's what we call an adhesion contract. Adhesion contract is a take it or leave it kind of contract, and that's really an adhesion contract is not legal because it's too one-sided. Contract is supposed to be a meeting of the minds, right? Both people are comfortable with their specific performance, whatever they have to do. So, you know, if you're buying a house and somebody says, I want $300,000 for a house, I'll give you $250,000, and they say, okay, let's call it $275,000. You both agreed on the price. Your performance is to come up with the money. Their performance is to relinquish the house. Everybody's in the position they put themselves in, and they're happy. You get this adhesion contract, and it's take it or leave it. You know, like if you go to a hospital I've done this. You go to the hospital and they give you this agreement, this admission agreement, right?
Mm-hmm.
It's heavily wavered in favor of the hospital. So if you stand there and you strike some things out, I've done that before. And I mean, they get all bent out of shape. So you can't do that. I said, what do you mean I can't do it? It's a contract. There's certain things I'm going to agree into, and there's certain things I'm not going to agree to.
Mm-hmm.
I mean, not things where about who pays. I know when I go to the hospital, either I'm paying or my insurance is paying. But there's a lot of things in there that would, I think, are somewhat offensive. You know, where they have the right to make certain decisions that I don't really want them to make. You know, but it happens all the time. I mean, they're not challenged, so they exist. And when they're not challenged, they make them that way. Then they make them a little stronger that way, and then they make them a little stronger that way because nobody's really challenging them. And then eventually it gets to courts, and the courts say this is a one-sided contract. You can't have a one-sided contract. You have to have a meeting of the minds. You've heard that term before, and it's not a meeting of the minds if it's take it or leave it. Because the alternative is, I mean, you're in there, you need your broken leg set and pinned and fixed, right? Mm-hmm. And they say, well, you know, if you don't sign the agreement, we're not going to fix your leg. What's your position? You know, you say, well, I got my leg fixed. You know what I mean? You're being taken advantage not only taken advantage of, but at a vulnerable time. You're sick, you're hurting, you're bleeding to death, you need help right now. And they want you to sign a contract, and they want to consider that to be a binding contract. In my opinion, a lot of times it may be questionable how binding it is.
True.
First of all, I mean, you know, you don't have to, if you're not in your right mind from paying, I don't know if it's actual, you know, informed consent or not. Anyway, I didn't mean to get off on that track.
Well,
but you know, the estate planning is the same thing. I mean, it's an agreement when you do a trust. A will's not an agreement, but it's an instrument. You need to know what it says. You need to understand what it says. You need to make sure it says what you want it to say. Now, in a trust, the most important thing that people review in my trust is there's a section where it talks about distribution of property, where it goes at death. And they'll read that in the language, if they're happy with the language, you know, they're usually pretty happy. A lot of the other stuff in the trust is the stuff that makes the trust work. And a lot of people read that too. And it's interesting to them. But it's you know, it's the fact that the trust is an agreement, happens during life, and make the trust have the right to do this, this, and this, and the trustee, which you may also be, powers of the trustee can do this. You know, that's where we talk about if you need to change it or put property in or take property out. These are the people who have the authority to do all this. So, you know, I never mind when people read those things. But then I get some people, I had a good friend of mine that I did trust planning for, and he was kind of a self-made person, had a fair amount of wealth. And he just couldn't sign it fast enough. He'd just look at me as I explained stuff, and he'd say, Stan, just tell me where to sign this thing. And I said, well, you know what? I'll go through it quick, but I insist that I explain it. And he said, all right, go through it quick. And he would just, I mean, he just didn't want to be bothered with it. And I know he never read it. I thought, well, I know you're never going to read it, so I'm going to do this explanation to you, so at least you'll have that. But, I mean, that's okay, too, if that's what you want to do. It just can be inherently problematic because, you know, when that instrument comes up to be used, you're not going to be here. Mm-hmm. And you just want to make sure, especially the distribution of property.
True. And
I always go over that. Like, we have people, sometimes whether they read it or not, at the signing, I'll sit there and I will specifically go through all that, practically line by line, just to show them what it says. Anyway, but it's it's kind of a painless process when you do the trust planning. It's you just tell me how you. I often tell people, say, you know, this has to be put in words. So, you know, I put my whiteboard up, or at my seminars I have a PowerPoint. Mm-hmm. And I say, when I write these trusts, it's really all I'm drawing on the whiteboard in words. The visual diagram is so much easier to understand when to see it, but it's all that in words because we don't have diagrams in the trust. But when we put it together like that, I usually tell people, here's the best way to come up with your plan. Fast forward to the end. Fast forward to your death and say, okay, what would be my ideal end result at this time? Okay, we're thinking, okay, I'm going. What do I really want to be the ideal result? And if I would like this to go to my one kid, but I wouldn't want him to get it if he's still married to this person, or I wouldn't want him to get it if he's still under 18 years old, or too young in life, or just all kind of stuff like that. Well, that's exactly what I'm looking for. Write that down. Just write it down in a narrative. Don't give me any kind of special format. Just write it down in a narrative and say, I'd like to leave this to my kid, but I worry about him doing this habit that I don't like, and I would like his inheritance to be protected from that habit, or stuff like that. And then I can take that and back it up and get it into the language it needs to be in the trust. I guarantee it'd be hard to stump me. Every time I say I've seen it all, then something comes up that I haven't seen. But I've seen a lot of it, and I see a lot of things that repeat. So we know what we know how to handle that stuff. So if that's a good way to approach it. Fast forward to the end and give me the ideal result, and I can go with that.
Yeah.
So,
Well, in the experience you have, people don't realize how much you study estate law and estate planning, and you know what you're doing. You know what you're talking about.
I keep up with it, and I'm obligated to do that. My rules of ethics say if you're going to practice an area of law, you have to be competent in it. I mean, which makes you wonder, well, how do you ever start, right? And the way you start is by.
Well, I've seen some. Think, well,
Well, I don't know if it was you or Jeff, but I said something, I don't know, a couple months ago that a client came to me, but they want to do some trust planning. They did enough research on trust, that's what they wanted. Which is what the conclusion most people come to. If you do that little research, you find out the will's not the best thing. The will's a step in the right direction, but it's just not the best thing.
Not the way to go.
And so they come in and they were telling me that, and they were asking some questions, and I was answering them. And I would not just the answer, but I would explain why the answer is what it is, and stuff like that. And the one looked at the other and said, "I think we're going to go with this guy." And the other one said, "Yeah, I like him better than the other one." I couldn't help but ask. I said, "What other one?" They said, "We talked to another attorney, and she said, you won't believe this, but every time we asked him a question, he sat there and Googled the answer and read it to us from his laptop computer." They didn't say it, but not instilling a lot of confidence in it.
As Bill Engvall would say, here's your sign.
Here's your sign, that's right. Anyway, I do know it. I'm more than happy to entertain questions. It's hard to stump me with a question, although it is possible. We had something that came up recently was we were administering a estate, and the guy had a lot of property, and a lot of it he had self-finance. So he had a lot of deeds of trust out there paying to him, and that's it's kind of an asset, but it's kind of a debt, or stream of income more like to him. So anyway.
All right. Well, they hung up.
Oh, okay. Well,
they didn't want to wait.
If that was a call to me, go ahead and call back. We'll take it.
We'll take it.
I don't mind stopping in mid-sentence. I can usually pick up where I left off.
If Stan's talking, let him finish what he's saying, and we will.
Yeah, you don't interrupt my train of thought at my age, right?
And who are you again?
That's right. That's right.
Good morning, WDXE. You're on the air with us.
Yeah, I apologize, but I have a lag. He wasn't talking when I dialed, but he was when I didn't know what to say.
Oh, okay.
What he was talking about falls right in line with something on Dave Ramsey. Now, sometimes they're reruns, so it may not be right now, but this is something happened the other day. He was giving someone advice, and he thought he had it together until the lady said, "Well, I finished my law degree, and then I'll have to get my license," and I want to say Florida. I forget the states. And he said, "You mean it's not reciprocal?" So I thought about how sometimes he says things that say they contradict with what Mr. Pierchoski, and he's not an attorney, and vice versa. But I don't think people realize how much time it takes to get to where Mr. Pierchoski is. This lawyer was moving here and wanted to do what he did. It brings to mind another, how complicated and long it takes to learn it, but it brought to another thing that came to mind too is he mentioned one time how we recognize a law in Alabama concerning common law marriage, even though Tennessee doesn't. I was listening to another talk show, and he's not a lawyer or a fancy, but he was recommending it's TOD, but it's where if somebody dies, the title bypasses a will or a trust, it goes directly to the person, and it's not in Tennessee. We don't recognize that, but it seems to me if anybody had a trust out of town or a state or a will, they would need it reviewed here. It could be incredibly complicated. Just wanted to throw that out there.
Okay. All right. Hey, we appreciate your call.
Okay, so there were several things in there. I'll see if I can remember them all. First one was how long does it take to get to know this stuff, and a long time, probably hundreds of hours, if not 1,000 hours, especially in my asset protection stuff. Okay, but there's a lot of resources available for me to learn that. I run the Tennessee State Planners Forum. We do the first Thursday of every month, for the whole state, and we spitball ideas and stuff like that. So it takes a lot. It takes an effort. You can't just walk into it. It's not much taught in law school, but anyway. The next thing was she brought something up by common law marriage. And well, I did talk about this once before. Common law marriage is a marriage not sanctioned by the state. And I'm going to come back to that because it's going to take a little more discussion. And the last thing she mentioned was TOD and passing outside of a will or a trust for land. Now, unfortunately, Tennessee doesn't have that yet. But they kind of do and they kind of don't. The legislature has been written, it's been proposed, it's not been voted on and enacted yet. But I hope they will, and I think they will. But Tennessee's going to invoke the TOD, it's called transfer on death. It's like making your deed, your land, have a beneficiary. And so at your death, if you say, I'm leaving this to Bill across the street, at the moment of death, it belongs to him. The transfer's on death. It's kind of like POD on a bank account, pay on death. It's a better way to look at it is it's a beneficiary, which is a contractual transfer of whatever the property is, money in the bank account or the real estate. So, but it's not really in full force and effect in Tennessee yet. I fully expect it to be so. I'm not sure what the holdup is. I'm not part of the legislature, but I think that they're going to the trouble to draft the rules. A lot of states have it. Right now, we have provisions that you have to cite a certain provision in the probate code to give your executor the ability to transfer real estate. If you just say, I named my son the executor of my will, and I want to make sure all my real estate gets transferred to this person, this person, this person, they may or may not have the authority to do that if they don't invoke the right statute. This would kind of fix a lot of that, or not fix it, but make it easier to transfer property if you wanted to. A lot of states have it. I think we'll end up with it, but right now at this very moment, it's not been enacted in the code. Now the other thing was the common law marriage, which is an interesting concept. When you talk about a common law marriage, they're talking about when you go to a wedding, you always hear the preacher say something like, "With the power vested in me by the state of Tennessee," right, or wherever you are. So it's a state marriage. It's a statutory marriage. And what's a common law? Marriage is a marriage without the involvement of the state, which people think, well, that sure can't be legal. I mean, the first question that comes to my mind, were there ever marriages before the state of Tennessee? And the answer is obviously yes, probably for a couple centuries, probably, right? The concept of man and woman pairing up for life is scriptural, comes from God himself, right? And that's who sanctions marriage. He says so himself in Scripture. This is the union you make before me. And so, there's common law marriages. Common law means just that. It's ingrained in our jurisprudence. It's not necessarily codified anywhere. It doesn't need to be. It's by operation of law. If you do something long enough, it becomes the law. It's called common law. And so they do exist. Now, certain states will say, we recognize common law marriage, and some states will say we don't recognize them. Now, that does not mean what it sounds like. In other words, Tennessee's a state that says we don't recognize common law. Well, with one caveat that I haven't got to yet. But we don't recognize common law marriage in Tennessee. So if you have a common law marriage and you're in Tennessee, it doesn't mean they're going to say, they'll send the police to your door and say, you guys got to move out and live in different houses, you can't be together. It's not that. You can get a common law marriage in the state of Tennessee. When they say they don't recognize it, here's what they're talking about. They're saying, and this all came out of, I don't know if you remember this, LB, you probably do. I don't know how many years ago, every bit of 40 years ago, maybe even more. Remember the actor Lee Marvin?
Yes.
He had a partner for many years, a woman they lived with, and they went separate ways. I don't remember her name. I remember him, but I was probably in my early 20s when this happened. And they went to court because he was an actor and had a fair big estate, and the court awarded her certain assets because they had lived together. They called it palimony. Do you remember that? Palimony, yes. P-A-L. And what the court said was because they had been together for this time, had children together, she had earned an equitable interest in his estate. Okay. Now, but here's what they mean when Tennessee says we don't recognize it. Okay, if you have let's talk about a marriage that they do recognize. If you have a statutory marriage, and then you get a Tennessee certificate of marriage, right, from the Department of Commerce, Now, what the Department of Commerce has to do with marriage is a subject of a whole nother topic.
That's where
Maybe
you
we'll
send
get there
your money
someday.
to.
Well, maybe we'll get there someday, but, you get a marriage certificate from the state of Tennessee. Now, if you ever wanna get out of that marriage, the only way out, there's two ways out of it. One is by death, or the other is by a statutory divorce. Okay. Now, when you get divorced, that's statutory, meaning there's all kind of rules with it. Meaning, if you're going to get a divorce, we have to look to see if your spouse is entitled to alimony. We now call it spousal support. Or if you have kids, do we have custody, and do we have child support? And all of those things that we ask the court to do for us in a statutory divorce has the power of law, and they can enforce it. So if you agree to custody and you shortchange the other party with their custody, they can complain, and they can enforce it, right? When they say we don't recognize it, if you have a common law marriage in Tennessee and you decide to split up, and you go to court and say, I want to sue this, it's not my husband, but I want to sue my partner for spousal support or child support, the courts are going to say, we don't recognize the remedy because that's a statutory remedy for a statutory divorce. Mm-hmm. You're in here with a common law divorce, which is not even the right word, common law splitting up, and asking us to apply statutory remedies to a non-statutory situation. We don't have the jurisdiction to do it. So it doesn't mean you can't have a common law marriage. They don't recognize, you can't go in and ask the court for regular marriage and divorce remedies. Does that make sense? Mm-hmm. And it's not that they don't, but Tennessee, the caveat with Tennessee is we don't recognize a common law marriage. However, we will recognize a common law marriage if the common law marriage came from a state that did recognize it. So I think Alabama recognizes common law marriage. And I've seen, when I was doing criminal work, I've seen several marriages where people were common law married in the state of Tennessee or Alabama and have transplanted here. And if they wanted to deal with it, there would be certain recognition that Tennessee would offer, because it's called full faith and credit. If you read your Constitution, Article 10, there's a phrase in there that says that all the states, back then we didn't know how many we were going to have, we didn't have 50, said all the individual states will give the other states full faith and credit, which means if you come to a state with something like a trust or a will or from the one state, the states you end up with will give it full faith and credit. It means we'll deal with it from here under. Mm-hmm. And typically, if it's something that's governed by state law, like a will or a trust, so if you move to Tennessee and you have a Virginia trust and you pass away here, Tennessee will administer the Virginia trust using Virginia law, but we'll do it here in Tennessee. That's called full faith and credit. And they'll do that. They have to. It's constitutional.
Well, true.
So when the last thing she said is if somebody moves from a state with something that was created in another state, you certainly have to have that reviewed. The answer is, well, not just because you moved. It doesn't have to be reviewed to comply with Tennessee law, because it doesn't have to comply with Tennessee law. Yeah, it's going to be administered under the law that it was formed under. But what I've seen people do is that when they bring me an out-of-state trust, they say, well, there's several changes we want to make to it anyway. So we'll make those changes, but what we can do when we make those changes, we can change the situs of the will. We can change it to be a Tennessee will. Mm-hmm. It's called a restatement, and so we can do that, and if that makes the people comfortable. But of and by itself, if the only factor is we've transplanted from this state to the other state, no, it doesn't have to be reviewed for accuracy, and it doesn't have to be changed. Now, if the person just says, I just feel better, because I'm here in Tennessee, I would just feel better if it was a Tennessee trust. Well, then you do it, but they're just doing it to feel better, not for any legal reason. But if you're going to make some changes anyway, we might as well make it a local one.
Yes.
So, again, these other states will recognize it. We're not. That was the whole concept in the Article 1 of the Constitution, was that we're all separate states for our individual pursuits, but we're all collective for our unified protection. Mm-hmm. Right? In other words, we get attacked. It's not just North Carolina being attacked and everybody else saying, "Oh, you're on your own, North Carolina," something like that. But North Carolina can, operate a lot of things under state law that they can control themselves. Then some things are federal. Some things are preempted by the feds. They control it everywhere. Good example of federal preemption is counterfeiting. Tennessee has a law, and it's called, oh gosh, I can't think of the name. I think it's called something like wrongful simulation or something like that. If you make it's kind of counterfeiting, mm-hmm. Okay? But they can't do counterfeiting because the feds have preempted counterfeiting. They do counterfeiting everywhere. but it's something like that. Criminal simulation or something like that is what it's called. And that's when you make an instrument that purported to be something it's not and try to pass it off. It kind of falls into the fraud. But
well, like I said, it was
so it's not
a Louis Vuitton, but or whatever that big name brand is, but it's really
yeah,
not.
right.
Yeah.
Like a Gucci, but you spell the name wrong.
Yeah.
But again, if it's actual counterfeiting of money, the feds are the only one who can prosecute that. But the answer to the caller's question, don't panic if it's from out of state. But probably the majority of things that people bring out of state, they want to revise anyway for other reasons, because it's 20 years of age on it, and things have changed. They want to make it different. I think we're going to make those changes. Let's just go ahead and change it to a Tennessee trust, because we can make it part of the amendment. So, but no reason to change it just because you can. Now, why would somebody not change it if they came here? Let's say you come here with a Georgia trust, because I'm thinking of one recently. Come here with a Georgia trust, and you want to know if you need to change it. Well, one of the things I will look at before, if they're not going to make any, if I say, well, do you want to make any changes? They say, no, we just want to know if it's okay here. And I'll say, well, who are the people that are the successor trustees, the ones who are going to deal with the administration at death? They said, those are our kids. Where are they? Well, they all still live in Georgia. Well, I said, well, I'd leave it. Since they're the ones going to be administering it, why should we make these two or three Georgia residents, your children, have to administer this trust under Tennessee law? Why don't we just leave it to Georgia, and they can do it there where they're at? So there may be reasons not to change it, even though you've relocated. But by far, what people usually end up doing is changing it. But again, from a legal standpoint, you don't have to. How's that for a mouthful?
Boy, I tell you
You
what.
gotta be careful when you ask me a question. I got short answers, I got long answers, and I got medium answers.
I'm glad you're an attorney and not me, because I couldn't remember all that stuff.
Oh, it's nothing hard.
Oh.
It just comes natural to me, I guess. But she was mentioning it takes a while to get where you're at. It does. And here's a pet peeve I have. I'm an attorney. I'm part of the attorney world, but I don't agree with the industry in a lot of things, and that is, you really need to know what you're doing if you're going to practice an area of law. And I take issue with. Well, we don't have yellow pages anymore technically, but if used to when you used to advertise in a phone book, you'd pull up and you'd see a 2-page ad for an attorney firm. It would list every area of law that they practice. Now, if you're Morgan & Morgan and you have over 1,000 attorneys, you have several attorneys that do each of those things, right? But if you're a sole practitioner or something like that, and you just list all these things that you do, I've contested you couldn't do any of them well. I mean, it's too much. But, we don't. You can hone in on certain areas and only practice those, which is what I do. I mean, I have a good working understanding of a lot of other things that I don't do. I don't do adoptions. I know how they work. I don't do divorces. I know how they work. If somebody comes to me a divorce, I say I'm not the best person for it. I don't deal with it. I don't keep up with it. I kind of know how it works, basically, but that's all. I used to do a lot of criminal work. I've forgotten some of that, but I remember a lot of it. But still, I refer that stuff out because it's no longer in my lane. And if you're not in your lane, you're not getting what you're paying for. And I think a lot of people pass themselves off of, I can do anything. I can do anything. All these subject matters I can do. And I dabbled with bankruptcy, and it's like, what, if you did bankruptcy, you'd better be the only thing you do, because that is the one convoluted set of, or immigration law. Just very specific stuff, and it would take a lot of time to learn it, and God bless those who do it, but I just don't see how it's possible. Somebody might call in and say, well, I do it all and I'm good at it. And maybe you are, but I'm going to say the average person or average attorney they deal with, like you see a lot of attorneys that just do family law. Family law is divorces, it's adoptions, it's custody battles and stuff like that. And that's kind of all they do. And that's a smart thing to do. Stay in your lane and do what you do and do what you do very well. That's what I do. I do estate planning. Estate planning is a field of stuff, but it's not a huge field, but that's my lane. And anything in estate planning I feel comfortable doing. And I feel comfortable, whatever I do, when somebody comes in, I do a trust plan or any kind of trust or any kind of a testamentary administration, I'm confident, I feel like I can defend everything that I do because I feel like I know what I'm doing. And that's the way you should be. But I have come across a lot of trusts that are brought to me that have been written, and the most gingerly way I can say it is they were inartfully drawn. Let me put it that. I guess I could be harder on it, but inartfully drawn. And they needed fixing and correcting. Because, I can tell when I look at it, it's somebody that doesn't do this much. And they just, somebody comes in, I guess they want the business and they say, yeah, I can do that, and figure they can hurry up and Google it or look at something. Here's a classic example. Let me see where the time is. We got a few.
You got about
We got
7 minutes.
We got 7 or 8 minutes. Here's a classic example. I brought it up before. Everybody heard what the concept of power of attorney is. And power of attorney is a document where you give a trusted loved one the ability to make decisions on your behalf, whether it's medical or financial, okay? Well, I have seen so many power of attorneys that come from attorneys. They're very short. Now, I'm not saying length has anything to do with it, but when they're short, here's what they say. They'll say you can do this, this, and the other thing, and there will always be a paragraph in there. Some of the older school attorneys have used this all the time. There's a paragraph in there that says, this power of attorney, and my agent, I give them and I incorporate all the powers under the code by reference. So we go to the general durable power of attorney chapter of the code, right? And they want to bring all those codes in there instead of listing them all in the document. I list them all in the document because there's two kinds of powers in power of attorney. There's standard powers, which do come over by reference, and then there's also enhanced powers. The enhanced powers are non-delegable rights. And you can say, my agent can do anything and everything I can do, which sounds all-inclusive, but it isn't, because it doesn't bring over the non-delegable rights, the enhanced powers, because in order for you to give your agent the enhanced powers, you must have them express within the four corners of the instrument, which means you got to write the power out, what's exactly in the code. Otherwise, I don't get it. Now, for some people, those standard power of attorneys will work simply because they're just doing standard stuff. But in trust law, and for my clients that have trust, a lot of the things that their agents are going to need are in the enhanced power, so they got to have them. So my power of attorneys are very long, not meaning they have to be long, but they're long because I recite all those powers in the code in the instrument, because I take the position it's better to have a power and never need it than to not have it and have to go to court to get it, if you can get it. I've seen that happen too. And so it's so easy just to bring it in. It's it's a waste of paper and a waste of ink. So what? I don't mind killing trees. That's what they're for. That's what God put them here for, right? To use them. So I don't mind making it a lengthier document because it's got what I need. And my power of attorneys have withstood some pretty heavy scrutiny. I've had people in Vanderbilt where they asked for my power of attorney. And you got an army of attorneys up there. I like to tell this story. It actually worried me for a while, but made me feel good in the end. It had a couple up there, and the husband was terminal, and they were up there, and the legal department up there called and asked me if they could get a copy of the power of attorney. And I said, sure. And I'm thinking, okay, what are we looking for? So I sent it to them. And then I got back to them within a couple of days and kind of said, everything okay? Because, you wanted to see it. I know where it's going, and it's a bunch of attorneys up there are going to be scrutinizing it. And the guy, he said, no, I'm sorry, I didn't get back to you. He said, we're used to, there was something they wanted to see if the wife could do for him. And he said, no, everything's cool. He said, we're used to not seeing it in these power of attorneys, and yours had it in there, so we're good to go. I should have called you and let you know. So I was worried, thinking, okay, I'm waiting for that shoe to drop, right? And what's going to happen? But they come back and said, yeah, it was there, and they're very, I won't say what the power was, but they're used to seeing it not there when it comes up. That's why they asked for it, just on the outside chance it was there, and they said it was there. It was great. And so everything went forward with what the doctors were trying to do, because you put it in there. And the reason it was there is I didn't single that out and say we need to put that in there. I put all the powers in there because I never know. I'll tell you an example of why I take the position, have a power and never need it. It doesn't hurt to have it. If it's there and it's the most, you say, let's say it's crypto, the ability to deal in financial power training, to deal with crypto coin, Bitcoin or something, digital assets. I don't deal with that, and that's stupid. My agent will never need that. Take that out. I'm gonna say, well, you never know. If it doesn't apply, it doesn't hurt to be there. It doesn't hurt anything. It can only help for any reason, right? Years ago, I had somebody in a trust plan or a power of attorney. We talked about afterborn or adopted children, and this person was, done with their child year in arrears, and they were very offended by that. And I said, look, it doesn't hurt to be there. I want it out. I let them talk me into taking it out. I took it out. About 3 years later, that person contacted me, and guess what? They adopted a child, and it wasn't there. And it was a big deal to get back to where we should have been if we had just left it in. So if somebody comes to me and says, take these things out, I said, I'm not going to do it. If you want something Without those, go to another attorney that'll write you one the way you want it. But I'm doing you a favor by not taking it out. Or a potential favor, so. Anyway, this looks like we're coming down the wire.
If it's nothing that's gonna hurt your heirs or,
No,
you
it
know,
doesn't hurt, it just never applies.
It just
maybe.
never applies.
The worst case scenario is it's NA, right, doesn't apply.
Yeah.
And so it doesn't hurt. So I've learned my lesson and I don't do that anymore. But anyway, it looks like we're coming down the wire. So, you know, this is a call-in show. We had a call today. We're here every Friday from 8 to 9, Bullets Booth Estate Planning. You have a seminar coming up on January the 24th, after the holidays are in the rearview mirror and you're ready to get back into things. You know, we kind of, it will be past all that. It's a Saturday, it's 10 o'clock in the morning. We call it Will's Trust in the Nursing Home. It's at the Star Theater right on the square in Pulaski. Not too early to RSVP for that. If you want to go to my website, which is estateplanstand.com, or if you want to call and just tell them you want to come to it, it's call my office at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222. And for the guy that always complains I say the number too slow or too fast or not enough, 931-363-7222. I get accused of talking too fast sometimes.
Well, it's all right.
Especially when my brain goes much faster than my mouth.
Well, we got just a few seconds.
Yeah.
You know, you're talking about to be an attorney and how much time you had to put in it. I probably shouldn't tell this, but I'm going to. When I was in high school, I had a guy in one of my classes that was just big blowhard, and everybody in his family was better than everybody else and all this.
Every class has one.
And he made the statement one day that he had a cousin that was really, really smart. And said that he was going to school to be an attorney. The teacher looked at him and said, "You don't have to be smart to be an attorney."
No, I agree.
But to be a good attorney, you've got to be smart.
Well, you got to understand.
Yeah.
Yeah, which I don't know if that's smart or not.
But I thought, you know, I think of that quite often. Well, all right, Stan, it's been great being with you. Jeff will be back next week.
It's always a pleasure to do this every Friday morning.
And January 24th.
January 24th, 10 o'clock at the Star Theater is the next seminar.
All right. Thank you, Stan.
Thank you.
Years ago is expected to appear in court
I like to say welcome to probably one of the fastest hours in my week. It always goes by so quick, you know. Probably not for you because you're on the radio all the time. Once I get talking about something, it just flies by. So you see, if Jeff would have just left me in here and left it on,
Yeah.
I would have filled the whole hour. Just talking.